our elected official webinar series. Tonight we have another in our series of land use webinars, and we're excited to have this presentation. It's one that at the Trust we see some challenges on, and a lot of questions and concerns from many of you out there that are serving in an elected or appointed capacity. And so we're excited to have this presentation tonight, and I'll introduce Elliot here in just a second. But just a couple of things before we start up, and I was told I need to go faster on on this and not talk quite so much. Tonight we're going to talk about group homes. This is one of those issues that is a challenge. But first of all, we have some controls on your control panel. If you have this displayed, if you don't see it displayed, you can move your cursor to the top of the screen and it will pull down. Just a couple of things. Everybody's muted at this time, so you don't have to worry about talking. But you can click that to either on your microphone to unmute your mic there. There's a chat box. It will either be displayed like this, or you can click on chat at the top of the screen as you pull that down, and you can ask questions in the question and answer sections. And I'll be monitoring those through the screen. We'd also like to know who attends. So if you're attending as a group, please send me an email at jason@utahtrust.gov and let us know who attended there. It's one of those requirements of our Trust Accountability Program this year is to have commissions attend that. So we'd love to have an email from you to let us know who was here. We do have some training coming up. We've got a great conference coming up on October 10th and 11th, day-and-a-half conference, and we've got some great presenters and speakers for that. We're excited to have that available for our members, and so be watching for some announcements coming up for that. And this webinar series goes on, and we do it about every other month and have a different topic. We do a quarterly elected officials land use training, and that's what we're doing tonight. And we're very fortunate to have Elliot Lawrence from the Office of the Property Rights Ombudsman's Office from the state. And he's an attorney with that group, and his function is to help out to smooth potential issues between property owners and local governments. So he's an expert in this field, and we're excited to have him give this presentation tonight. And so I'm going to pass over my headphones to Elliot. And once again, if you have any questions, please add those into the question answer, the chat section, and we'll be doing that as we go throughout the meeting. We'll also be doing some polls. I forgot to talk about that. We'll be doing polls just to kind of take the temperature of the group and see how you have dealt with this type of issue before on group homes. So once again, Elliot Lawrence. Let's go ahead with that. And go ahead and slide in there. You want this one up? Nope, not that one.
Those are the cases that we'll be talking about. Well, good evening, and appreciate the Local Government Trust asking us to do these webinars. Again, my name is Elliot Lawrence. I'm an attorney with the Office of Property Rights Ombudsman. Just briefly, like Jason said, our office is there to help property owners deal with governments, but also part of our mission is to help educate and advise local governments, and that's part of this doing these presentations here tonight. Our topic is residential facilities or group homes, and I know some of you may have dealt with these in the past or may be dealing with them now. there's several terms. Residential facilities is the term that's used in the Utah Code. We also use group homes, halfway homes, treatment centers, residential treatment centers. One of the cases we'll talk about tonight is called a step-down facility. But we use the term group homes to focus on all these. And these will include short-term and long-term homes, and homes for disabled, and also halfway houses that deal with, like, for example, emotionally troubled juveniles. We'll just refer to them as group homes. And go ahead.
Oh, yeah, okay. I'm sorry. I'm going to go ahead and run that poll, if that's all right. Sorry, I thought that's where we were.
No, I just want, well, to scroll ahead on what's on the screen are some handouts that we made up. And the group homes are frustrating. And I am a former, worked in the city attorney's office, and I dealt with a couple of these group homes, and I know what cities go through. And part of the problem is the law, really, and it's not an exaggeration, the law is constantly changing. And there's different nuances, and what worked even a few years ago no longer works. In fact, just a story, we were dealing with a group home application came in, and we immediately called the outside attorney, it's through Irma, and he came to meet with us, and he said before he left his office, he checked his computer and just to see if there were any cases that had come down that day. That's just an indication of how much this law is changing. It settled down a little bit, but still there are some new cases that are coming in. And actually part of the frustration, even though there are new cases coming in, there aren't that many. Most of the cases that you see reported are at the trial level. And rather than the circuit court of the appellate level. So, like I said, most of the cases that are coming up are district court. If you're familiar with the federal system, the federal district court is the trial court, and then it goes to Court of Appeal, and ultimately the Supreme Court. And the problem is there aren't a lot of appellate cases. All these cases sort of die at the district court level if they go anywhere at all. Another aspect, well, first of all, citizens, of course, don't particularly like group homes. And these homes, they feel more like businesses than residences. This was a case I dealt with, the city I was working with. We had a group come in, and this was basically they would be elderly disabled, I guess would be the term. And these were individuals, and as much as we love and support these people, this is a group of individuals, they could not take care of themselves. They needed 24-hour care. And this a company, it was a private company, they had purchased a home, and they were going to have these individuals live there, and the company would have their staff take care of them. And they came in, and it was it's been about 15 or so years ago, and they came in and said this is a residential treatment facility. And it went to our Board of Adjustment, and a woman on the Board of Adjustment, she just threw up her hands. She goes, I'm sorry, but this is a nursing home. And they immediately said, oh, no, this is a residence. This is where they will live. And she said, if you have people where you have staff that are taking care of them, she says, that's a nursing home. I'm sorry, but that's a nursing home. Well, unfortunately, the law is on their side, and it's considered the residence, as we'll talk about. And then another, I think maybe the biggest problem is that these applications, or the applicants for group home, have come in with a chip on their shoulder. And I don't know if anybody from the group home or from that industry or that group will are listening to this or will listen to it, but really, they really deserve criticism for that. They come in, like I said, with a chip on the shoulder, and they also make it personal. This is, and I am not exaggerating. I'm not making this up. This actually happened. It was a alcohol and drug treatment facility was proposed, and I was the attorney. I sat down with their attorney and the owners and representatives of this group, and I was trying to talk with them and tell them, the city is concerned about this, and they feel that this is being rammed down their throat. And they just smiled and said, "That's exactly what we're doing." They didn't even apologize. They didn't even blink. They said, "Yeah, we're doing this, and there's nothing you can do about it." And then they also made it personal. I was severely lectured by this group about how insensitive I was to the disabled, which, well, I was actually quite offended because my grandfather was deaf, I have a cousin who was blind, and another member, a close relative, has a developmentally disabled daughter. So I was actually quite offended to have them accuse me of being insensitive. So, but it's what you have to do. So, on the other hand, you have to remember that group homes are here to stay, and they actually do provide a service for people in your community. And finally, as we'll talk about a little more, local governments are not entirely powerless, despite what you may have heard in the past or from even other attorneys. They are not completely powerless. So if we can move down to the next page here. Anyone lost their mouse? Hold on one second. While we're doing that, if you've been following the legislature, the last legislature, this last winter, amended the Land Use Development and Management Act, and the amendments affected these residential facilities. And what you see on the screen or what's on the handout is basically what's left of the law. All references to residential facilities for the elderly have been removed. There is no longer the requirement that the residential facilities are or must be permitted uses in residential zones. What's left is Section 516, Section 520, that's in Title 10, and then there's parallel provisions in Title 17 for counties. And if we can annotate, let's see, show me that. Yep. What's left here is these three provisions. A municipality or local government may regulate these facilities as provided by the Fair Housing Act, the Utah Fair Housing Act, and the Rehabilitation Act. And secondly, any licensing is either with the Department of Human Services or the Department of Health. And what that means is no business licenses and no regulation by local governments other than zoning, and only what's allowed basically by the Fair Housing Act, if it boils down to. So that is your law. And so moving down, let's talk about these laws. Okay, bottom line. Group homes are residential facilities. They are residences. And as such, they are subject to the same rules and ordinances and laws as any other residential use. If you have a rule or ordinance that is applicable to residences, that is not applicable to residences, but is only applicable to group homes, you may have a problem with fair housing. Now, the Fair Housing Act was designed to prevent or prohibit discrimination against different groups, including the disabled. The objective is to provide equal housing opportunity. And you may have seen the ads, or if you purchase a home through a realtor, they'll have a little thing at the bottom that says equal opportunity. And they are required to do that. And the objective is to eliminate barriers for access to housing for things like race, religion, national origin, and disability. And I put here on the star right here. One of the arguments I mentioned earlier about the member of our Board of Adjustment that pointed out that what they were describing sounded a lot more like a nursing home than a residence. The Fair Housing Act has been it's been interpreted that these facilities, even short-term facilities, are residences, and so the Fair Housing Act applies. So that's the way the law has been interpreted, and that's the law of the land right now. The other law, Rehabilitation Act, was the original law that prohibited discrimination against the disabled. And from the Rehabilitation Act, I think the term was that the Americans with Disabilities Act was built on the Rehabilitation Act. Americans with Disabilities Act actually isn't mentioned in the state law, but it nevertheless applies, and it's important that we understand it. It also prohibits discrimination. It has been applied to zoning decisions. And then finally, the Utah Fair Housing Act follows the federal law pretty close. Well, I'm going to refer to all these laws as the Fair Housing Act, just for simplicity. And even though there are different laws, there's actually a lot of overlap. And what we need to know are basically what's in the basics of fair housing. Yeah, so let's see, we get just click and so. Well, this is where we're going to start from. Group homes are not exempt. The Fair Housing Act does not insulate these applicants from legitimate inquiries or from participating in the processes. And that really is the gist. That's pretty much the bottom line of what we need to know is the Fair Housing Act and these other acts, they don't remove group homes from regulation by local governments. But it comes down to is group homes are subject to the same regulation. In other words, you can't treat them differently. You have to treat them like every other residence that you would have in your city. And so there's three ways that you get in trouble under the Fair Housing Act. There's actually more, but these three are the ones that apply for our presentation tonight. Number one is disparate treatment, which is intentional discrimination against an applicant. The second way is disparate impact, which is the discriminatory effect of a practice or policy, even though that may be neutral. If there's an impact on the person with a disability. Finally, the third is a refusal to make reasonable accommodation for the account of the person's disability. So let's talk about these. Disparate treatment. That requires that there be direct proof of discriminatory intent, or if there's circumstantial evidence that can be rebutted. If you have an ordinance which singles out group homes so that they're treated differently from other residences, that may be disparate treatment. For example, if your ordinance requires that a group home receive conditional use approval, but a single-family residence in the same zone would not require any other approval other than the building permit, then that may be disparate impact. Another thing is the statements about group homes that are the city officials have directed to that application. Anything that's considered a negative comment or a disparaging comment about those people, we don't want those kind of people in our town. And even well-intentioned, if there's a concern about the safety of children, it's a kind of a halfway house type of setup over in West Valley, and there were all sorts of comments came in because actually fairly close to an elementary school, and so there were all sorts of comments came rolling in about protecting children against these people. Some of them had mental disabilities, and some of them were recovering addicts, and so on and so on. Anytime those kind of comments come in, the red lights should go off because that could be disparate treatment. Another ordinance which would treat group homes differently is the dispersal ordinance, which were kind of in vogue about 20 or so years ago. And this basically required that group homes it's usually a quarter mile or something, a half mile. It had to be so far apart. It could be close to a school or parks or churches, things like that. If you have an ordinance like that, repeal it, because that is evidence of discrimination. Now, disparate treatment is direct discrimination and applies to the application that's before you, or the proposal that's before you. The second area, or the second problem is disparate impact, which is not necessarily direct proof of discrimination, but it's proof that a policy or a rule, even a neutral rule, causes a significant disparate effect on a protected group. The cases that I've talked about have emphasized that it's a significant effect, and not just well, there's a slight difference, but it has to be a significant effect. And the way this is normally shown is that statistical evidence that members of a group with a disability are treated negatively in a substantial way than other people who are not disabled. And I want to stop here on the bottom of the page. You'll see that the disparity between the disabled and non-disabled is shown. There's a slight difference, and it's a subtle difference, but it's significant. A lot of the cases and a lot of the arguments come in that the discrimination is against a particular group or this organization that's going to organize a group of the disabled that are living in a group home. And the courts, there's a court case, one of the cases that we'll talk about discusses that it's a slight difference between discriminating against a group living in a group home and the treating them differently because of the disability. And that's a slight shift, but it is significant because, like the court pointed out, if it's we don't want group homes, we don't want large groups living in this size in residential neighborhood. That's a problem with the group home itself, as opposed to we don't want people with this disability living in our neighborhood. That's discrimination against the disabled. And I guess I should pause right here and point out disability includes emotional and mental disability, and specifically, this is specifically in the law, former alcohol or drug abuse, not current, but former. So recovering addicts are considered disabled under the federal laws, the Fair Housing Act, and the Americans with Disabilities Act. So treatment facilities for recovering addicts come under this law.
Can I ask a question at this point then? If recovering addicts, so if somebody proposes a sobriety house, what they call that, we basically take a large home and sublet apartments and say we're going to have AA meetings in this home, right? And this is a residential treatment facility or group home. Is that something that's covered under the ADA?
Well, if they're living there, then it would come under the Fair Housing Act and the ADA. A facility that's just, if they're using it for meetings, first of all, the Americans with Disabilities Act would certainly apply because you're opening it as a public accommodation. The Fair Housing Act wouldn't necessarily apply if no one's living.
But if they subletted that as they took a house and divided out apartments in there and they were living there, even if it's in a single family zone, would that still be covered and something that we would have to allow?
Yes. If people are living there, it's considered a residence. One of the cases I looked at, it was a short-term treatment center. It was only 6 weeks, and it was very clear that an individual would complete this program and leave. Also, most people, at least on a short-term basis, the short-term treatment, for all intents and purposes, it really isn't a residence. They don't legally change the residence. They don't change their voting record. They don't, more often than not, don't change their mail. They stay there on a temporary basis and then go back to, well, their homes. And so, in spite of that, these are residences. And so the Fair Housing Act applies. And in your situation, that would apply because if there are people living there, even if it's in a single-family home, that's indistinguishable from every other home in the neighborhood, it would still be a group home, and the Fair Housing Act would apply.
Thank you.
So, so those are the disparate impact and disparate treatment. Those arise when someone says something, the proof of discrimination. We'll talk about the case. This is from St. George. I guess we'll talk about. We'll start off right now because it comes into the reasonable accommodation section, which is this is the one I think most cities would be dealing with because it has to deal. Reasonable accommodation is just a spirit, but it's a modification of a policy. A policy or a rule that is needed so that a disabled person can have an equal opportunity to use a dwelling. I'm going to talk about this first case. If you're looking at the materials, it's the Cinnamon Hills Youth Center, which is in St. George. They actually came up with a pretty clever idea. the Cinnamon Hills, this company, I guess it's a company, they actually ran or are running a group home in St. George, but they wanted to have, this is the step-down facility I mentioned earlier. It was a step-down facility, which would be, it's a little less supervision, and it's meant to be help people. This is actually juveniles with emotional problems. They help them transition into, I guess, what we'll call regular living or independent living. And so what this company did is they bought a motel in St. George, and their proposal was to run a motel on the first floor. It would be run like a regular motel, but the second floor, the second story, would be this, what they call the step-down facility, and have these individuals living there. And St. George, their ordinances prohibited any residential uses in that zone. It's a commercial zone. And so the city said, look, nobody can live here. This is not, there are no residential uses allowed in our commercial zone. There were some minor exceptions, and so they denied the application, and this group appealed it and went to the 10th Circuit. And the 10th Circuit actually agreed with the city. And they pointed out, and this is, I included some quotes, is that the objective is to provide equal housing opportunities, not preferential and not better. And so what the court pointed out is, in the second paragraph, there is no comparable housing opportunity for the non-disabled. The failure to create an opportunity for the disabled isn't necessary to achieve equality of opportunity. And that's a good example of what the Fair Housing Act requires is that these facilities be treated like everybody else. And so in the Cinnamon Hills case, nobody could live in this zone. Nobody could do what Cinnamon Hills was proposing. And so it wasn't discrimination to say that they couldn't. And it also wasn't a reasonable accommodation to basically ignore that rule and say, well, okay, you can go ahead and do it because you're dealing with disabled people, but nobody else gets to do it. That would be preferential treatment rather than equal opportunity.
And before you move on, we did have a question come in that says, our code limits individual dwelling units to 4 unrelated persons in certain zones. Can this be applied to group homes in those zones?
It can if it's applicable to everybody. That what you're referring to is a pretty common limitation on occupancy, where there's they place a limit on unrelated persons. A lot of times we'll say a family is related person is any number, with unrelated is only so many. But yes, it can. But it's also subject to a reasonable accommodation, which several of the cases have dealt with. Now, on this down towards the bottom, what makes it reasonable is, first of all, it's an undue financial burden, which for most local governments, there really isn't a financial burden involved. But it could also be reasonable if it requires a fundamental alteration in the nature of the program. And this, again, was applying to the St. George situation, where St. George prohibited any residential uses in that zone. So it would be a fundamental alteration of their zoning ordinance to allow a group to live in this, to allow a residential use where one shouldn't have been allowed. And then, like I said, it's a fundamental alteration of the zoning scheme. So if you have a zoning ordinance in place, you're not required to completely ignore it, but you only show that it is so unreasonable it would be a fundamental change in the zoning, how your zoning scheme. It would be this a radical alteration of the zoning scheme. Okay, so the problem is that first of all, these are very fact specific, and what constitutes a radical change in the zoning scheme? It doesn't. And what this, of course, this is actually a case from Wisconsin, and what they talk about is they have to balance the needs of both the city, the local governments, and also the disabled group. To what constitutes a reasonable accommodation. So that brings us to the question that was asked about the occupancy limitation, but also the other trying to talk here. The other question is the building size, which is also an issue that comes up with these group homes. The case came down, this is actually out of Draper. And this, again, was a trial case. It's not supposed to be appellate level, so the trial level. This a group came, Draper has a limitation, it was 8 unrelated persons. That was their ordinance, which frankly is quite a bit. So that's quite a few people for unrelated persons. This group came and they were proposing a facility. This is a residential facility for the elderly disabled, again disabled, but they wanted to build a facility for 24 people. And the city said, well, our limitation is 8. And their argument was, well, it's unreasonable to go from 8 to 24. And also, the city claimed that it was unreasonable to build a facility that size. It was 14,000 square feet, I think was the number, in a residential zone. And the city said, well, they compared the other homes in the neighborhood, and they were, the case didn't give a number, but they were probably the traditional size homes. And a 14,000 square foot home is probably 3 or 4 times what a normal residence would be. Well, the court pointed out, or what the court discussed was, there was no size limitation on the building. And so, in other words, anybody could build a 14,000 square foot home if they chose to do so, because there was no limit. The city had not placed a limit on the size of the bulk of the building. So in other words, the way to look at it is the city had already agreed that a building of that size could be built. The fact that no one had actually done it doesn't mean you can't do it. There probably would have been a different outcome if Draper had imposed a limit on the building, not the building size so much as the building bulk. And several cities have done this. I don't know if any of you have ever heard the term McMansion. It's a play on McDonald's, but they're all over the country, and they started cropping up in Salt Lake, and I guess other places in Utah. But in Salt Lake, and especially in the central city, the lots are actually quite small. If you're familiar with the Avenues area, which is up near the university, very small lots. What happened is actually this building got built, someone bought the lot, tore down the house that was there to a small lot that fit nicely onto this property. And they used every square inch of the property that they could. They were still within setbacks and all that good stuff, but they used every square inch of that property that they could, and they built, I think it was a 3-story building. So you have this massive house on a tiny lot, and yet it was perfectly legal because they complied with all the zoning ordinances that were there. And so because of that, and there were actually a few other examples, I believe Salt Lake City, and I know Salt Lake County is because I actually spoke with the gentleman just a couple of weeks ago that's dealing with this. They've developed what we'll call a bulk limitation. And it's in the ordinance. It's actually a fairly complicated mathematical. There's all sorts of, it has to fit within what they call an envelope, that the building has to fit within this envelope. The reason I'm bringing this up is if Draper had that type of limitation, then they could take that to when this group came and proposed this, giant house. Draper could say, "Wait a minute, our ordinance this is the limit that's imposed by our ordinance. Nobody can build a house that size." And so, just because you're building it for the disabled doesn't mean that you can build it. And it's reminiscent of the St. George case, where in that case, nobody could do what the group home was proposing. So it wasn't discrimination to say, no, you can't do it just because you're disabled. It's not a reasonable accommodation to make us completely ignore our zoning ordinance. It also follows along the same line of the maximum, the maximum occupancy. And this is one where a lot of people have dealt, or I guess it has some heartbreak over this, because everybody knows that every neighborhood has the house that's got 1 million kids and even more dogs, that the place is a mess, there's constant noise. But at the same token, everybody knows a house where there's a lot of kids and even a lot of dogs, and disease is a pin. In fact, we're in North Salt Lake right now, and this is an attorney I worked with lived in Bountiful, and he said there was a family in his neighborhood. They had 8 children, and so there's 10 with the mother and father. There were 10 people. Well, the 2 oldest children got married, and they and their spouses lived in this home. So at that point, there were 12 people living in this house. Really a regular, basically a normal, what we would consider a normal sized family home, nothing extravagant. And he said that place was as neat as a pin. The yard was always in good shape. I pointed out that with that many kids, they would have plenty of people to take care of the yard. So the number of people is an issue, but everybody knows of a family that has 10 or 12 kids, and they're able to live there without causing a lot of problems. So how does it apply to group homes? Well, they started putting in occupancy limits and saying, all right, you can have your group home, that's fine. 5 is a common number, 8 is a common number of unrelated people, and but they still object to that. And the reason is that they don't make as much money. A group home needs so many people in order for the company that owns it to be profitable and providing the opportunity for the disabled. I guess we should backtrack. These occupancy limits, first of all, they're allowed. Several cities have them. And in fact, Logan and Ogden and Provo of all imposed occupancy limits. All those cities have something in common, that they're all university towns. They all have colleges, and so they have a lot of college students. And not only here in Utah, but around the country. Ann Arbor, Michigan, it's home to the University of Michigan, which has thousands of students. They actually have occupancy limits that only so many unrelated people can live in a rental home. So, what if you're disabled? Is it a fundamental alteration of your zoning scheme to say, well, I can't have 8 people, I can't make my business run with 8 people, I need 24? Is that a fundamental alteration of the scheme? Under the cases that have come down, it would be at least arguable that you could limit the number of people because it would apply to everyone. Remember, it's not the fact that they're living in a group home. What you have to show is that they need the extra, they need a larger or a higher occupancy limit. They need more people living there to get an equal opportunity to use housing. In other words, they need this reasonable accommodation to enjoy a housing opportunity that people who are not disabled would not enjoy. And this brings us to maybe, I think probably the one that really, I think gets people really worked up is you have a third party arguing that they need a larger home for more people. They need a larger home to make more money. And the argument is they will make, this means that they will have more opportunities for the disabled. The Draper case that I mentioned, they make that argument. They said they needed, this kind of circular reasoning is that the company proposed building a facility for 24 people, and then they argued that they needed the city to allow them to have 24 people so they could make enough money for the facility that housed 24 people. And the court, again, this is a trial court. This is the district court in Salt Lake City, agreed with the company and said allowing this 24 people rather than 8 was a reasonable accommodation. My opinion is there is more to be written on that topic. Given these more recent cases, the one out of St. George is only a year old, and a few other cases that have come down around the country, the whole idea that a company needs to make money in order to provide the opportunities for more people, for more disabled people, I think there's going to be more to be written on that, especially in light of if there are ordinances in place that apply to everybody or generally applicable. In other words, nobody gets to do, like in St. George, nobody can live in that zone, so it's not a reasonable accommodation to say, well, we'll let a group home for the disabled just because they're disabled. You're not giving them an equal opportunity, you're giving them preferential treatment. So that brings us to the end. And, first of all, are there any questions that come in?
I haven't seen any more questions come in so far.
All right. The last page of the handout, what can cities do? And I guess I want to pause here for a second. I want to make it clear that I don't want to sound negative about group homes because they do provide a good service. They help people. There are people that need this type of treatment. And and also, for every story you hear about something bad happening in the group home, there are stories of good things. I spoke with a woman today. She lives across the street from it's a group home for teenagers, for girls actually, girls with emotional or mental problems, and she said they've had absolutely no trouble at all with them. And yet, I also spoke with another woman in Ephraim. They're across the street from it's a group home. I think it's for girls, another group home for girls. And she said as soon as it opened, they started catching kids sneaking around their backyards or their garages and sheds and whatnot. So yeah, there's a lot of problems. I personally had I wasn't directly involved. I kind of caught the tail end of it because I was doing work with law at the time. And you may have heard this. I think it was in Cedar City. This was for juveniles and the teenage boys. It was understaffed, and there was only one counselor there, and two of the boys actually killed the counselor. And I hate to. It's a terrible story. Like I said, I got involved with the tail end because it was workers' comp thing. But yes, a terrible thing, and it was a group home. And I am aware of the stories and the problems. So are the group home people. And that kind of kicking that off, we want to talk about what we can do with the city. Number one, like I said, recognize that group homes do help people and they can be part of your community. And also number two, be fair. Group homes are subject to land use regulation just like every other land use. And they should be treated like any other residence. If you have any part of your ordinance that separates those out, that they have to get approvals that no other residence has to get, then you need to take that out of your ordinance and treat them like any other residence. Number three, be prepared. I'm an old Boy Scout, so be prepared. This is the situation I talked about in Draper. If you don't want an oversized home in a residential neighborhood, pass an ordinance that limits the bulk or the size of the home. Check out the ordinances in Salt Lake County, possibly other cities, of what you can do to place a limit on the bulk of a home. And it's not enough to say, well, no one's ever done that, or it's not compatible with the neighborhood. That's not going to work. It has to be in the ordinance. Put it in the ordinance. You've got well, that's at least a step in the right direction. You still have to deal with the reasonable accommodation aspect of it, but just as long as you have a zoning ordinance that applies to all residences, if anyone can do something, then basically what the law says is everyone can do the same thing. Sorry. Number four is be informed. One aspect, I didn't talk about this, but this also came up in the Draper case. What they argued was there wasn't opportunity for this type of facility. It was, again, for the elderly and disabled. They said there was a limit or maybe zero opportunities in the city of Draper. Well, if you're familiar with the Wasatch Front, if you're not, you can look at a map. Draper doesn't exist by itself. I think it's perfectly within reason to include the opportunities that are in other jurisdictions. If there aren't opportunities in Draper, there might be plenty of opportunities in Sandy. It's only a few miles away. And even in small towns. If there aren't opportunities in Ephraim, there may be opportunities in Manti. So it's okay to look beyond your jurisdiction within reason at the opportunities that would be available for treatment. And again, you need to document the nature of your residential neighborhoods and use the data. There are 4 words that I hate to see together, and that is compatible with the neighborhood. Almost every city and county uses those words, especially in the context of conditional uses. The problem is it means nothing because it means everything. What does compatible with the neighborhood mean? And the problem with that, it gives too much discretion. A planning commission or a city council can decide what's compatible and what's not compatible. Without what you need is you have to have some hard data. And this is actually a problem in the Draper case. The judge criticized the city for not having this information available. And again, I mentioned this before, if you have a part of your zoning ordinance that is treating group homes, singles them out, get rid of it. Just amend it as soon as possible.
So what type of language would you use instead of compatible with the neighborhood? How would you really approach that?
Well, what you have to do is you have to decide what you want in your neighborhood. This goes back to what I said, number 3. The example I gave. If you don't want gigantic homes, then put it in your ordinance that limits the bulk of the home.
So specifics versus generality.
Exactly. And something you can measure, something that in other words, if I go to your city and I want to know how big of a house I can build in your town, I open up your zoning ordinances and it will tell me how big I can build in your town. It's not enough to say, well, this is what everybody's done. Without that limitation, anybody can do it. I gave you the example. This happened in Salt Lake City. We've got this ridiculously large house in the avenues of Chavez. It's actually rather small. They're nice little homes that fit nice on their lots, which are small. And you got this humongous house. So, and the city was kind of caught off guard. And I believe Salt Lake, I know Salt Lake County has, they've adopted a kind of, we'll call it bulk ordinance, I think, and it gives a mathematical approach of the size and the bulk of the building you can build. That's going to lead to the next one is be smart. Don't say anything that's going to disparage a group home or the disabled or the teenagers with emotional and mental problems. I don't know if any of you have seen the movie Blazing Saddles. At the end of the show, it's a group of former slaves, and they help a group of white settlers save their town. And they said, well, we want to live here, and they're all kind of uncomfortable about living here. And they finally said, well, okay, you can stay. And the mayor says, but we're not taking the Irish. Don't say things like that. I can't imagine anyone would say, we don't want the Irish in our town. So don't say, we don't want recovering addicts in our town. And along that line, it's okay to talk about problems that have happened with group homes, and especially group homes that are run by the same organization. One of the cases that's on our list is Kansas. It's the Keys Youth. And they actually had done their research, and they had made a list of several problems that had been at other group homes. And the court said that was okay. And be aware, these facilities are licensed by the state. And so if there's a problem, the state can step in and regulate. And then finally, number 6 is be the leader. In other words, be the grown-up. A lot of people are going to come in and they're going to be upset. They're going to be angry. and they're going to say the things like keep up the Irish. And as the leaders of your community, you need to be above that and keep the discussion on a proper level or a professional level. And along that, while we're talking about that, it's okay to ask questions about these group homes. A lot of times, and I've told you about the ones I dealt with, they just bristled that we would question them, but that's perfectly okay, because how else are you going to find out what to do? And it's okay to approach that from in a professional manner and say, look, we have questions, we want to know what's going on, and help us understand. And avoid being argumentative. And again, be the grown-up. Someone has to be the grown-up who needs to see it. So be the grown-up and approach it from a professional manner. And finally, I didn't put this on the list, but lawyer up. If you're approached by a group home, or you hear that the group home is considering moving in, spend a nickel